Hello and welcome to our Mulberry Talent Partners Leadership Conversation. I'm going to give attendees just a few moments to begin logging on. Okay, it looks like everyone is beginning to roll in. So again, welcome to today's Mulberry Talent Partners Leadership Conversation. I'm Laura Back. I'm Mulberry's Director of Marketing and Events. If you're new to us, welcome. Just a little bit more about Mulberry. We are a full service staffing and recruiting agency headquartered in Portland, Oregon, with a brand new office in the San Francisco Bay Area. We specialize in the professional placement of human resources, professional and financial office, payroll and operations positions for direct hire, temp to hire, and contract roles. I would encourage you to check us out online at mulberrytalent.com, where you can browse through our full suite of service offerings, as well as our candidate profile search function. Jumping right into introductions, today we are joined by our fabulous founder and president, Lauren Francis. Lauren founded Mulberry Talent Partners in June of 2017. We're coming up on our 4-year anniversary. And she brought over 25 years of talent acquisition and entrepreneurial experience when she launched Mulberry. And we are so pleased to welcome our guest speaker today, Marc Alifanz. Marc is passionate about helping employers manage and mitigate their legal employment risk, not only through reactive management of issues after they arise, but by avoiding them altogether through respect, education, and positive HR management. For over 17 years, Marc has helped businesses do just that as a big firm litigator, corporate in-house counsel, and nonprofit executive. Today, Marc will be sharing about employment law changes, both current and prospective, under the Biden administration. Without further ado, I'll pass it over to Marc. And while Marc pulls up his slide deck, I just wanted to share that we are able to add up to 15 minutes to the call today, going to 12:45 to save time for some questions. So please feel free to use that chat function or the Q&A, and we will do our best to get to any and all questions that come in at the end. Without further ado, Lauren and Marc.
Good afternoon, everyone. It's so good to see everyone, and we're so happy that Marc has joined us. So I met Marc here in Portland because he attended the same university as my daughter, not at the same time, but I was just so curious to the universities in the Midwest, and you just don't see that many people from WashU and St. Louis. So I reached out to Marc, and we've been friends for a number of years, and we're just very, very pleased and honored to have you on today. So we have a lot to get to, so we'll let you get to it, Marc. Thanks again for joining us.
Thanks so much, Laura and Lauren, for the introduction. Can you just confirm for me that you can see the slide deck? It looks, you can see the intro slide?
Yep, I can.
All right. So we are going to move through this very quickly. So what are we going to cover today? I thought very briefly, I know you've seen the advertisement putting this out there, but we're going to talk about some of the philosophical differences between the Biden administration and the prior administration. We're going to talk about some employment law changes that are already been undertaken by the new administration. We're going to have some prognostication about what additional laws may be coming and what will happen with some of our favorite agencies that many of us deal with, like the EEOC, OSHA, and the NLRB. A little disclaimer here, I'm only going to cover federal employment law during this conversation. I just won't have the time to get into Oregon or Washington, though I may have 1 or 2 notes about that as we go through. Okay, so why am I qualified to talk to you about this? Lauren got into a lot of that and Laura in the introduction, but I thought I'd tell you a little bit about myself. I have been practicing employment law for almost 20 years. I was a litigator for the first 10 of those years at big firms on the East Coast and then at Stoll Reeves here in Portland. I'm currently working more as not a litigator. I work at a law firm. I do pre-litigation. I help clients manage potential claims, but mostly I try to be an advice attorney and help them avoid getting those claims in the first place. I've also served as in-house counsel for KinderCare Learning Centers, which is a 30,000 employee company in, at the time, 40-something states. So I've managed employment litigation and claims from all around the country. I also moonlight as an HR executive and legal advisor for nonprofit healthcare. I'm currently serving as an interim general counsel for Central City Concern, which is the largest homeless services provider in Portland. I'm also a trainer. Training is my favorite thing to do. It's similar to what we're doing right now, but I love getting in there and talking to teams and managers in particular about respectful workplace and how to manage how to identify and better connect with your workers so that you can avoid potential harassment and discrimination kinds of claims. I also have a podcast, which I'll talk a little bit more at the end. So I'm only with you for 30 minutes. And I have enough materials here to literally talk about all this new stuff for hours. So this is going to be super high level. And in the interest of time, I'm going to move really quickly. So for real, I normally prefer a really interactive session where I'm not the one doing all of the talking and we have lots of good discussion. But today I have to average less than 1 minute per slide, and that discussion isn't going to cut it. So I keep asking myself, why did I choose such a huge topic for such a short talk? But I think this is really useful and helpful information for all of you. So with that much to cover and so little time, yes, I'm mostly going to read the slides and talk at you instead of with you, except we're going to start out here right now with a question for you. And I believe all of your mics are muted, but if you can put some comments in the chat, and which Lauren can see, I'm curious, what do you think are the differences philosophically between the Biden administration and the Trump administration? I'd love to get your comments. Some of these I think are going to be, I would think, just to give a little hint of my next slide, might be a little bit along the lines of, well, every time you change the party of the president, you get a little bit of a shift in philosophy. But then also, are there any differences specific to the Biden administration that you've been seeing or thinking or hearing about or worrying about? And I'm curious for your very quick hot takes.
So we have some coming in. We have pro-employee versus pro-employer, less regulations with Trump, workers' rights are more important than employer rights. The Trump admin tended to be a bit more employer focused, while the Biden admin tends to be a bit more employee focused. Biden's philosophy is equality in the workplace. Biden admin is less class division.
Wow, you guys are on it.
Yeah, they are. Wow.
That's great. I mean, basically, I can skip my next slide now. So some of these major differences, I think I agree with every single one of those. Thank you all for the quick responses. So some of the major differences are, in fact, really typical of the difference between Republican and Democratic administrations. That is, Democrats tend to be more pro-employee and pro-labor. Republicans tend to be more pro-business and pro-employer. Now, I would note, as a hippie liberal Portland guy, right, who also does defense employment work, right, being pro-labor and pro-better working conditions and pro-respect is also pro-business. I wish it wasn't set up with that rubric that being pro-employee is anti-business or vice versa, because I think they all go together. But you know, what do I know? What I do know though is when you mesh those things well, you end up with fewer claims. Not what we're here to talk about, but you know, I'm just going to put that out there. So that said, within that Democrat-Republican administration difference, my sense is that the Biden administration is going to be more pro-traditional labor than any other recent Democratic administration. Okay, that plays out in a number of ways. We'll discuss it more, especially at the end of the presentation when we get to the PRO Act, which has many employers shaking in their boots a bit right now, if it were to come to pass. But Biden has gone on the record saying he wants to be the most pro-labor administration in history, and I believe he is setting it up to do that. Whether he'll be able to accomplish that is another question. So briefly, we're going to talk here about what's already happened in 4 months of the Biden administration. We're going to start with executive orders. He issued over 30 executive orders in just the first couple of weeks. Not all of these are employment, but just generally, he's going crazy on, or went crazy on the executive orders. For those of us, just a little primer here, executive orders are the rules promulgated by the president in furtherance of policy or other objectives as part of executing responsibilities of the executive branch, carrying out laws that already exist. So when you hear about executive orders, these aren't new laws, but they can feel like it. And sometimes they get challenged because they may fall outside the scope of what the law is really meant to do. And presidents have been taking more and more liberties with executive orders over the last several administrations, in part because Congress has been so much more obstructionist, regardless of which party, if there's different party in power from who has Congress or who has control of Congress, it really hamstrings what the president can do, and presidents have been using these executive orders much more. Notably, and not shockingly, many of the new executive orders that we have seen are simply undoing the executive orders of the prior administration. So it's like, you do that, we're going to undo that, we'll do a few new things, and then if it changes back again, the next person can undo all of that. Briefly, I thought I would talk about some COVID executive orders. There were 4 key ones here. I'll just throw them all up there. These aren't rocket science. So, they're saying that federal employees have to wear masks. OSHA needs to review workplace safety standards. We got to wear a mask on domestic and international travel, and some rules governing reopening and continuing of schools and early childhood education. Notably, and again, I think I'll leave those there given how much we have to cover. I would expect significant shifts or changes coming to some of these executive orders, which made a lot of sense in January. Now we're in May. We're opening up, hopefully within the next couple of days, to vaccinations down to 12 years old, which is very exciting for me as I have 12-year-old twins who will finally be able to get vaccinated. But as those vaccine rates continue to go up and the incidence of COVID tends to go down, I would suggest that by the fall or into the winter, once the incidence of COVID is so low, many of these executive orders will be obviated, meaning they won't serve the same purpose anymore. But I think that will be a slow burn. A couple of other key executive orders that have come out. An executive order on preventing and combating discrimination on the basis of gender identity or sexual orientation. So this expands federal non-discrimination protections based on sexual orientation and gender identity. It reverses many of the policies implemented by the Trump administration and aligns federal protections with those already found in a lot of state laws like Oregon and Washington. So what's happening at the federal level for some of this isn't super relevant for us in Oregon because we already have state protections, and in Washington as well. We already have state protections that cover a lot of this. Another executive order is the executive order, because these are like tongue twisters, on advancing racial equity and support for underserved communities through the federal government. This repeals an executive order put out by President Trump very late last year, which was on combating race and sex stereotyping. That sounds like a good thing, but what it was actually doing was, and you can read this, federal contractors after November 21st were required to include a provision that prohibits any workplace training that inculcates its employees in any form of race or sex stereotyping or any form of race or sex scapegoating. So this is saying you shouldn't be telling, it sounds like it's saying you shouldn't be telling employees about, or promoting sex stereotyping, right? Which of course we don't want to promote that that's a good thing, race or sex stereotyping. We don't want to promote that. But what it was actually saying is that trainers like myself aren't allowed to discuss theories that demonstrate that bias actually exists. So someone like myself who would come in with a respectful workplace training, I saw this and I was like flabbergasted when this came out last fall, because it would mean that I can't come in and say systematic racism in society and employment exists today in America. So it actually was serving as a way to deny that these problems actually exist. This executive order now, instead of denying the existence of racism and bias in our communities, now recognizes the existence of these entrenched disparities in the law and public policy and establishes a systematic approach to advancing equity, which means I can go to a federal contractor again and talk about that. We've got an executive order on protecting the federal workplace. This applies to federal workers, but I think it's a harbinger of things to come, or at least policy objectives to come. This implements a $15 minimum wage for federal employees and restores collective bargaining power and protections through an order rescinding the prior administration's order. Again, here we see, you know, a little tit for tat here. You do one thing, I'm going to undo it and do something else. That limited collective bargaining power of federal unions and made it easier to terminate the employment of federal employees. That's gone now. And then an executive order on enabling all qualified Americans to serve their country in uniform. This, again, revokes the prior administration's memorandum barring military service by transgender individuals and directs military leaders to take steps to ensure all otherwise eligible transgender individuals who wish to serve in the military can do so openly and be free from discrimination, including establishing a process by which transgender service members may transition gender while serving. So this is obviously a far cry from what the Trump administration was pushing on this subject. It has hallmarks and callbacks to those of us old enough to remember the 90s and Don't Ask, Don't Tell, and the fights over gay and lesbian individuals in the military. Now that has shifted to be a battleground around transgender individuals, and the Biden administration has made its position very clear. The DOL independent contractor rule. This is something that I wanted to talk a little bit about. You know, the punchline, I'll get to the punchline first, which is that there's not a big change here, but I thought it was a good excuse to talk about something that I think is really important for most HR and employers to be thinking about and don't think about enough. So historically, the Department of Labor has used this economic realities test to determine whether a worker is an employee or an independent contractor. And that economic realities test is a balancing test. So you look at this group of factors. I'm not going to read them all to you, but you look at this group of factors and you say, on balance, do more of these factors weigh in favor of being an independent contractor or weigh in favor of being an employee? Okay, and it's subjective on that level. And you can go through each one and have that discussion internally and say, well, this favors independent contractor status, this favors employee status. But in the end, it's which ones of these on the balance, you know, and it's a good set. I think it's a good set of factors that are really talking about how much control is being exerted and how independent is the worker really? Whose materials are they using? Do they have their own business? These are the kinds of questions that I always want to be asking. On January 6th, so this is about 2 weeks before Biden's inauguration, the Trump administration issued a new rule on this, which is crazy to me. Like, there's 2 weeks left. Like, what do you think is going to happen, right? Limiting the test to only 2 factors: the degree of control and how much opportunity for profit and loss is determined by the alleged employer, right? And the thinking was that these are going to more often favor an independent contractor status. So it would be more pro-business because businesses want to be having independent contractors instead of having everybody be an employee. That's an oversimplification, but I think in the end, that's what the thinking was. And it was scheduled to take effect March 8th. I really hope that you didn't start implementing this new rule because completely predictably, the Biden administration immediately delayed it. And just last week, on May 6th, it formally scratched the proposed rule and reinstated the prior rule that I showed you on the last slide as the final rule. So nothing ends up changing. There's not any current expectation, at least on this area, that the Biden administration is looking to make any other changes. Again, I'll reiterate what I said at the top of the last slide. This is a huge issue across workforces. There are many clients. Anytime I go in and audit this for a client, I find at least a couple of misclassifications in there that we end up needing to talk about relative risk of having somebody misclassified. If you aren't if you aren't confident about your classifications, this is a really important one to call up your attorney and start having a dialogue about it, because the back pay penalties related to a misclassification can add up, especially if you have a lot of individuals identified as contractors. Okay, we're moving right along here, though the time still passes really fast. All right, we're going to do some federal agency updates, and we're going to start with the EEOC. These are interesting, the federal agencies, because they tend to follow policy-wise the administration in power, except there's a limiting factor here, which is that a new president can't appoint new members or new commissioners until such time as a term ends. So currently, well, and I guess I'll point out, so it's a bipartisan model for the EEOC, and the party in power gets to have 3 seats, or the party in presidential power gets to have 3 seats, and the opposing party has 2. But you still can't replace those until the terms are up. So as it stands right now, Biden is president, but there continues to be 3 Republican and only 2 Democratic members of the EEOC, and that will continue until over a year from now, when former chair Janet Dillon's term expires in July of 2022, and Biden will then be able to add a 3rd Democratic member to the EEOC. So there's lots of things we might expect the EEOC to do under a Democratic administration, but those won't happen until next year, or the back half of next year. What he has been able to do is change the chair and vice chair to be the 2 Democrats. But that's really, I don't know, functionally it doesn't do a whole lot, because they're still going to get outvoted 3-2 on most issues. There are some hopes that because of this, there will be some opportunity for bipartisanship and trying to float some middle of the ground kind of proposals for the EEOC. We'll see. We'll see. So a few anticipated changes here. I'll start off. So I guess I'll note, so Biden's indicated that he intends to fully empower the EEOC to, quote, address discrimination in the workplace and help close the harmful and unjust gaps in wages and employment opportunities. He said he's going to double the agency's funding and empower the EEOC to initiate investigations for all areas of discrimination under its purview. So we're going to see just this broader push to strengthen anti-discrimination laws from the administration, and doing that through the EEOC. So very quickly, we expect to see some changes around LGBTQ protections. The administration has released an executive order that implements the U.S. Supreme Court's ruling in the Bostock v. Clayton County case, which was the blockbuster case last summer, where the Supreme Court affirmed that discrimination on the basis of sexual orientation and gender identity is a form of protected sex discrimination nationally, federally now. So with the executive order, Biden has now directed agencies like the EEOC to review and consider whether they need to revise, suspend, or rescind actions, or promulgate new actions to address sex discrimination, including discrimination on the bases addressed in the Bostock case. Biden's EEOC may also issue enforcement on sexual harassment prevention. I don't know a whole lot about this. I just starting to look it up. But there was a work in progress here that's apparently stalled out in the Office of Management and Budget Review process, though I haven't really seen what the substance of that was going to be. Age discrimination. Biden has indicated that he intends to protect older Americans against discrimination in the workplace by, among other things, making it easier for workers to prove that they were the victims of age discrimination. Since the 2009 Supreme Court decision in Gross v. FML Financial Services, plaintiffs alleging discrimination under the Age Discrimination in Employment Act have been required to prove that age was the but-for cause of the harm they suffered. So it wouldn't have happened but for the discrimination, as opposed to the more common Title VII factor, the motivating factor theory, which is it could have been one of many, and that's enough to find liability. So they're going to be looking to shift that standard from but for to motivating factor for age, as it is for a lot of the other Title VII protections. Moving on, equal pay data reporting. The Biden administration is looking to boost pay transparency for all U.S. workers through better data collection, a move that academics, attorneys, civil rights groups say is necessary to close a workforce racial and gender pay gaps. The president and vice president have identified that pay data reporting is integral to closing the gender and race pay gap. And more importantly, implementation of a new reporting mechanism does not require congressional action, and therefore there are no shortage of options for what the EEOC can do there. There's an interesting battle going on around conciliation. Conciliation is the process when an EEOC charge is filed, where you try to get the parties to resolve the claim short of litigation. There's currently a Trump administration under former Chair Dillon proposal to update the conciliation program and encourage employers to voluntarily resolve discrimination charges by giving employers more information about what was discovered as part of the investigation by the EEOC. So this is calling for more transparency towards employers so that employers have that information and are therefore maybe motivated to go and pony up a little bit more and approach that conciliation process to resolve claims. Democrats say no, and there's already currently proposed resolutions to rescind the prior proposed rule. So I actually don't think we're going to see a whole lot of movement there. Definitely, we're going to see increased enforcement and litigation. Now, interestingly, in 2020, last year, the EEOC secured more than $535 million to resolve workplace discrimination claims. Roughly 1/5 of that, $106 million, came from litigation resolutions, the highest amount that the EEOC has recovered in 16 years. Although some observers expect the EEOC to be more litigious under Biden, those record collections took place under Trump. So if the trend continues, we can expect to see increased enforcement activity over the next 4 years. However, former Chair Dillon, one of the Republican members, has stressed that litigation should continue to be a last resort and has pursued an agenda that favored mediation over legal action. I don't think once that policy objective will be what carries the day, and the Biden administration, once next summer comes along and former Chair Dillon is gone and there's a third Democrat on the EEOC. All right, moving along. Oh my gosh, the time just passes so fast. OSHA, briefly, some anticipated OSHA changes. Definitely we're going to see an increase in OSHA inspectors. We expect the president to double the number of OSHA investigators currently there. There are roughly 760 now, compared to 1,000 or so who were in place a decade ago. Even if they are able to start doing that, it's going to take 18 months for the new inspectors to get trained and begin really conducting inspections, but expect to see more OSHA knocking at your door. Finalize a permanent infectious disease standard. This was some interesting history that we don't have time to get into, but after H1N1, the Obama administration spent time developing a new infectious disease standard for OSHA that would have required health facilities and certain other high exposure workers to permanently implement infection control programs to protect their workers. We can expect, given COVID-19, as the dust starts to settle here, we'll look to implement something similar to what the Obama administration tried to do with H1N1. And then we're going to return to the original electronic reporting rule. In 2017, the Obama administration, OSHA began requiring certain employers to report employee injury and illness information. Under the Trump administration, they did not enforce that. We expect it to go back. So there may be more news coming in terms of reporting information. Department of Labor, I'm not going to spend much time here. That's our new Labor Secretary, Marty Walsh. We can expect to see DOL trying to really address or potentially change laws around overtime and white collar, the FLSA, joint employer regs, independent contractors, tip credit and tip pooling, and an increase in the minimum wage. NLRB, wow, this is going fast. Okay, National Labor Relations Board. Again, they have 3 Republican members. One of those terms expires on August 27th. There's currently 1 Democratic member and 1 vacancy. We can expect the Biden administration to fill that vacancy, and then the expiring Republican seat in August. So by later in the year, we should expect to see Democrats having a majority on the NLRB. It's taking a lot longer for Biden to fill this role, and I think that has to do with some other drama around new general counsel that he appointed that we're waiting for confirmation on for the NLRB, and then I think he'll get going on that. But I would have expected this to go faster. Some anticipated changes. Again, I'm just going to throw these up here pretty quickly so you can see them. I think easing or eliminating restrictions on forced recognition is huge. Broad expansion of joint employer responsibility, potentially huge. And again, the NLRA, National Labor Relations Act, and labor law is one of those areas that really vacillates from one administration to another. And there's significant ability for employer, or for the National Labor Relations Board to impact employers and to impact how easy or hard it is to form a union or stay in a union. And we can expect the Biden administration to pull out all the stops to increase union membership and erase barriers. And so I'm just throwing these up here. We don't have time to talk about all of them, but these are really all difficult for employers, especially those who are not currently in an organized workforce. I think we're going to be seeing some real changes, especially if the PRO Act gets passed. And I don't think it will, but this is the Protecting the Right to Organize Act. If it's passed, it will result in significant changes to labor law under the NLRA. Some key provisions: it would impose up to $50,000 penalties against employers that interfere with workers' organizing rights. Currently, there are no penalties. Compelling binding mediation and first contract negotiations where agreement is not reached within 90 days. Banning employers from holding mandatory meetings with their employees, including what we call captive audience meetings, where you can get all the employees together and talk about how great you are and they don't want a union. May not be able to do that if this passes. It would reinstate the persuader rule from Obama, which is that employers would have to disclose third parties that are offering advice and planning as part of a union campaign to try to prevent the union from organizing. Codifying into law the more expansive Browning-Ferris joint employer rule and the 2014 representation election rule with shorter union election timelines, and permitting workers to engage in secondary boycotts and preventing employers from permanently replacing strikers. These are some very fundamental changes. Currently, I believe every single, maybe with one exception or two exceptions, Democratic senator has signed on to sponsor this. However, I don't think that with the filibuster still in place, that this is going to pass anywhere close to its current form. I do believe that they will be working on some modification to this to amend the National Labor Relations Act to make it a little bit easier to organize, but they are going to need some Republican support to do it, unless the Democrats are able to get Manchin on board with eliminating the filibuster, which I haven't seen that that's going to happen yet, but who knows where we'll be in a few months. Very briefly, the Equality Act adds, this is again another proposed law, adds sexual orientation and gender identity as protected characteristics to a number of civil rights laws. This already passed in the House. Biden has made it a priority to pass this, but in his first 100 days, but didn't. This would also update public spaces and services covered in the current law to include retail stores, services such as banks and legal services, transportation services. These important updates would strengthen existing protections for everyone. Additionally, Biden has expressed support for expanding protections for pregnant, senior, and disabled employees. The Paycheck Fairness Act, I'm not going to spend more than 10 seconds on this because we already have the equal pay law in Oregon and Washington that essentially does what the federal law is trying to do, which will make it harder to have pay disparities. Right now, the federal standard is a factor other than sex would be a legitimate reason for a pay disparity. This would update it so that it would be objective factors such as education, training, or experience would be reasons to do that, but not any other reason. That more or less tracks the current Oregon equal pay law. And I believe this is my last one. Nope, next to last one, paid federal FMLA. So this would be making FMLA be paid through some scheme where employers and employees would contribute, much like we're seeing in some of the paid leave laws in Oregon and Washington and other states. So again, this may not have the huge impact on Oregon and Washington it would in other states. And then the minimum wage, it's currently $7.25 an hour, which is crazy. States obviously are higher. New York City is over double that for large employers at $15 an hour. Biden has made it very clear that he wants to push the fight for 15 and get to $15 an hour minimum wage nationally. Wow, that was a lot. Okay. We update all of this information at Bullard Law on our website. We do alerts and you can subscribe to get them in your email. And so that's the link. I'll have this on my last slide as well. I also co-host a podcast called the Hostile Work Environment Podcast. You can find it anywhere you get your podcasts, where we really try to take employment law and employment law news and make it accessible for the HR professional, and we really have a lot of fun with it. And it's all the most down and dirty cases and bad employer stories, and it's a ton of fun. And then if you have any questions, there's my contact information, as well as that link and the name of my podcast and a very cute cat. Thank you.
Thank you, Mark. We have had some questions come in. Let's see. So Jill asks, are you also tracking all of the federal law changes impacting federal benefit or employee benefits, including price transparency, out of network requirements, and other no surprises billing practices? She hopes that you'll do a webinar with us on that one as well.
That would be great. And I have just the person, one of my colleagues is a benefits lawyer. I don't touch any of that. So I don't know any of it, but I know as a law firm, we are very much on top of that. And my colleague, Kara Backus, is a fantastic employee benefits attorney. And she will be on top of all of those things. And maybe we can talk about bringing her on to talk about benefits.
That'd be fantastic.
Right.
Another question that came in from an anonymous attendee: what changes may be on the horizon for the OFCCP?
Oh, that's a whole can of worms, and it's not one I'm particularly informed on. I'm not going to be one of those lawyers who BS's his way through questions like that. I have had experience with OFCCP and affirmative action plans. I don't have a lot of recent experience or personal experience related to it. I would expect under a Democratic presidency that to the extent we see changes under the OFCCP, that they are going to be more pro-employee and increasing restrictions and restraints on employers. I just don't know how or if that would play out or when it would play out. I don't have that enough of that background to keep track of it to answer that question right now.
Mm-hmm. Let's see. Scott asks if you wouldn't mind sharing the current 1099 contractor qualifications once again.
Yeah, give me a minute on that.
And then Charles asked if the $15 an hour federal contractor rate will extend to the private sector.
Well, so that's what I'll answer that question first. It will if the federal minimum wage is changed.
Right.
Okay, so currently it's just for federal contractors. If this federal minimum wage change gets passed, then yes, it will apply to private employers, not part of the government. And I'm backing up to get to those criteria. Don't let me pass it. There we go. Next slide. There you go.
Great, thank you.
Hopefully that's helpful. That's all available, and this also matches Boley's wage and hour division economic realities test. It's a little bit. I put up a little bit of a hybrid of the two here. So sometimes it's 5 factors, sometimes it's 6 factors. These are generally what the factors are going to be. This is one of those areas though where I actually keep this chart because it's so complicated. This is just for Oregon. I keep this chart right here. Lawyers have cheat sheets too. These are all the different ways to interpret independent contractor status versus employee status, depending on who you're asking. So you've got the Oregon Department of Revenue versus the Wage and Hour Division for Boley, which has a completely different standard than the Civil Rights Division for Boley. It's the same, and nope. And then workers' comp is a completely different one also. So this is for purposes of this classification for federal FLSA, kind of law. But depending on what the area that we're talking about is, it's different factors and different tests.
Great, thank you. All right, I think that wraps it up for questions. So that brings us to the end of our conversation. For our loyal audience, thank you for joining us today for today's leadership conversation. I would encourage you to visit us online at mulberrytalent.com, where you can check out all of our previously recorded conversations as well as upcoming ones. Here are some that we have coming up later this month. We're going to have Kia Myers Duggan in for a career conversation on how to plan your career pivot. And then in June, we're going to have 2 leadership conversations, one on June 1st about pay equity with Mary Lou Cleary and Krista King of Reach CDC. And then in mid-month on June 15th, Julie Kearney will be with us to talk about employee engagement and why it matters. And then here are some ways to stay in touch with us. So again, thank you for joining us today. And thank you, Mark, for such an incredible wealth of information. We will be sharing this recording with all attendees later on this week. So be sure to check your email to make sure that you didn't miss anything in this jam-packed webinar.
Thanks so much for having me today.
Yeah. All right, until next time, everyone.